Judge Washington looked right at him and said, no, you're not. He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, Nelson?
Your Honor, I don't object to the outbreak in regards to defense counsel's request. However, I believe counsel is new on the case, is not aware of something that comprised the public defender of. Earlier this week, this defendant made threats to witness at preliminary examination.
Yes.
A new charge,
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of his conduct. And as a result of that new charge being authorized, we are requesting remand. We have previously advised the public defender's office.
Judge Rand Washington is in the office.
Your Honor.
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for his bond.
Sir, what did you want to tell me?
sir.
Well, Mr. Buckner, I advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
Well,
okay, on Tuesday, I had a hearing for a situation that I was allegedly accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed else. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, and I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Rand Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me. said, Mr. Buckner, is threatening my witnesses in court. This is what this same prosecutor said. Judge Ray Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Hold, stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review, I just got it this morning. But we were informed immediately after the threat occurred, she informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Yana, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Yana, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Yana.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, I'm not there. I was not there, Mr. Michael. Daddy was. I'm not sure is this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things there, and I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video. Somebody from your office, Mr. Brown, was handling his exam, correct?
Yeah.
Okay.
We just talked about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say just to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you to say anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My dog's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up, and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor in you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there. But I'll pass the matter. Sir, you need to just quiet down, please. Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
Arraignment.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. You understand that? Mr. Buckner, you can sit down while we go through this.
All right, so I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional outbreak. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are.
So there's no video.
You may want to mute that.
So this is my life. This is my freedom is just snatched from me, and I was understanding in this son why I came to the church. Y'all just talk to me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said about video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was the Judge Simpson giving the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th and Judge Washington work? Okay. Attention. I understand the attention. I just, from the time, and I apologize ever since, and I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge that Ms. Johnson, Ms. Washington want to find out. Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Thank you.
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. Then I need to be heard on it, and I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that the 22nd is not.
All right. Well, all right. Right, but I think that will be before Judge Washington. All right. And on that case,
The room tightens as the prosecutor steps in, voice steady but loaded. This isn't just background noise anymore. This is where everything shifts. He starts laying it out piece by piece, tying the defendant's behavior directly to what just happened in court. Now the pressure builds. The allegation hits harder, words spoken in the gallery, right after testimony, not somewhere distant, not misunderstood. Right there, right then. The tone sharpens. This isn't being framed as emotion or frustration, it's being framed as intimidation. Direct, personal, targeted. And just before the weight fully lands, you can feel where this is going, a push for a massive bond, built on the idea that this wasn't a momentary lapse. This was a threat that crossed a line inside the courtroom itself.
his bond would continue. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
Allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the court, and there was nothing. They will be able to prove that all that stuff.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is first this Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. Walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that she had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no coaching order as for residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is greatly concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and the state.
So I'm going to respond, John.
Yes, sir.
Obviously, very clearly means something different to the prosecution than when described it as an angry outburst. It doesn't rise to show any attempt to keep anyone doing anything except that angry outburst. They went ahead and tried to charge or witness intimidation. This is something based on what they saw in the context and unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper conduct, you'd agree.
That's right. Making a bond with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. Context.
What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they...
The judge has heard enough, and the shift is immediate. The language tightens, more controlled now, but far more serious. He's not debating what could have happened. He's focusing on what it means if it did. The concern turns specific. Not abstract danger, not general risk. One person, one target. That's where the focus locks in. There's a brief pause, just enough to feel the weight of what's coming next. Then it lands. The court acknowledges the defendant may not run, but that's not the problem. The real issue is risk, behavior pattern. And right as the decision breaks through, the consequence follows immediately. Bond set high, restrictions locked in, movement controlled. No room left for argument. The court has drawn the line and it's not moving.
That there, if said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate, should it be. That type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash assured. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
It's possibly from Judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, I mean, it's a community of people that was helping me, sir, and I know everything I'm saying, because you've already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her, he ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown.
Yes. Thank you.
No, I don't, but I conditions. Okay. All right. Thank you, Mr. Brown, and I appreciate that lesson on how to conduct a court. No, I always appreciate the help. No, well, some places do it that way. Some, I just let people talk. Okay, you know that because you're still doing it. Okay.